Hello, I am Paige Douglas and this is my presentation about the reformation of the Land Registration Act 2002. Why is land registration so important? Well, land registration affects anyone with an interest in land, from businesses to homeowners. Land registration is governed by the Land Registration Act 2002, and with 86% of land in England and Wales reported to be registered, it is essential for society and the economy specifically that the registration of land operates effectively in order to prevent fraud and protect individuals with an interest in the property market. After replacing the LRA 1925, the LRA 2002 has been operating successfully since coming into force in 2003. Since then, many changes have occurred, such as the transition to an electronic land register, which not only improves conveyancing but also allows for an easier transfer of sales. Having said that, however, there has also been many problems that have occurred since its 12 years of operating. As identified in the Law Commission's report, Updating the Land Registration Act 2002, a consultation paper, it is highlighted that there has been a rise in the amount of fraudulent incidents relating to registered land. Fraud at this level occurs whereby, for example, Mr. Bowden purchases land from Mr. Calloway, whom he believes is the registered proprietor of the land. Unbeknownst to Mr. Bowden, however, Mr. Calloway is actually a fraudster, and the registered proprietor of the land is in fact Mrs. Appleton, who is also unaware of Mr. Calloway's fraudulent activities. Due to the fact that the sale occurred through fraud, the transfer is void at common law. However, Mr. Bowden now replaces Mrs. Appleton as a registered proprietor. Some years later, Mr. Bowden then decides to sell the land to his friend Mrs. Dean, who is now the new registered proprietor. Another couple of years pass and Mrs. Appleton finally discovers what has happened. As you can see, we now have a problem despite all three parties acting conscientiously. According to the land register, Mrs. Dean has been left with the land. Mr. Bowden has received the proceeds of the sale, but unfortunately Mrs. Appleton has been left with nothing. This therefore demonstrates weaknesses in the LRA, such as Section 58, which states that the register is conclusive proof of evidence. This is clearly a realistic problem in circumstances as previously exampled, although the provisions of the Act do take this into consideration by allowing scope for rectification. It has also been argued to undermine the guarantee of title. This is, however, a major topic of discussion, because although a rectification of the register may result in undermining the guarantee, if it is not done, innocent parties such as Mrs. Appleton are left victims of fraud. Such cases are ultimately very difficult to resolve, which illustrates the extent to which updates of the legislation are necessary. With the elimination of paper-based land certificates, the transfer to electronic records has left room for a rise in fraud. Although despite many practitioners and legal experts' concerns, it is not likely that the Law Commission are very willing to revert back to the land certificates, claiming that it is not a viable option. Nonetheless, there have been numerous alternative solutions that have been put forward, some of which include putting more of the risk of fraud on practitioners. The Law Commission's consultation paper outlines objectives that should be achieved within the legislation to help decide whether the register should be rectified or not. For the purpose of clarity, a point of finality should be established to protect registered proprietors from losing their title. The rules must allow for discussion when determining who can be expected to keep the land and who will be expected to claim indemnity. And ultimately, it must be reliable so that individuals who are wronged can claim indemnity. The Law Commission's consultation paper encourages the removal of the goal of simultaneous completion and registration from the LRA 2002. In doing so, it is expected that the freedom may create more effective avenues for electronic conveyancing to develop. Problems with the current legislation. Further issues related to the LRA include that at the time the legislation was being proposed, technology was predicted to develop far beyond that of what it has so far. It is therefore apparent that a more flexible approach to the development of electronic conveyancing is required. Overriding interests. According to Section 29 of the LRA, overriding interests and registered interests hold the capacity to bind any purchaser, future or present, of a registered estate. This is a problem because there does not currently exist a formula to determine the priority between two competing unregistered interests. Let us have a quick recap over some of the points made in this presentation. Who does the Land Registration Act 2002 affect? Well, like we stated before, everybody with an interest in land, for example landowners, conveyancers, businesses and mortgage lenders, are affected by the Land Registration Act. This then leads us on to our next point. Why is the LRA so important? The LRA 2002 is responsible for essentially ensuring the effective operations of our land administration system. This then allows for the running of an effective property market to exist. With such a large amount of registered titles in England and Wales, where there are uncertainties in the land registration system, leaves scope to also potentially damage the property market. Now let's go over the problems that we highlighted regarding the LRA 2002. Let's start with fraud. Since the replacement of the LRA, it has been reported that fraud related to the registered land has continued to increase. Reasons for this include a lack of security with regards to the new electronic register. Suggested solutions for reform include security with the electronic register to crack down on the different types of identity fraud that have been occurring. Although it has not been discussed about how they would go about implementing such security, all whilst maintaining the efficiency and easiness of the electronic register, one of the sole reasons for transferring from paper-based documents. Another problem related to fraud with registered land is that when it has occurred, it is difficult to resolve within law. Section 58 of the LRA establishes a guarantee of title. Although it must be noted that Section 58 of the LRA must also be read in context with the rest of the LRA to understand the limitations that are expressed when applied to cases of injustice through fraud. As there is no current system in place for the resolution of victims in these instances, it has been proposed that the objectives as set out earlier in the presentation should be established to ultimately set in place a rule of law to help courts to reach a fair conclusion, which can be applied to other cases as objective principles to follow. Moving on to electronic conveyancing. Given the emphasis that was impeded upon the transfer to an electronic database, it is important to review the extent of success of achieving the aims that were set in place during the implementation of the LRA. It has been raised that the high expectations may have been too ambitious, as forecasted development of the system had not reached its expectations. Therefore, given the complications that have arisen concerning its underdevelopment, it is clear that a reform of these goals are necessary. Suggested solutions include reverting back to the old method, although this is highly unlikely, as it isn't likely the costs for doing so would be reasoned. Alternatively, it has also been suggested that a change in the goals set for the development of the system may be enough to warrant further success, like it has been shown in other jurisdictions. Finally, the last point of the presentation concerns overriding interests. This is an issue in debate for reform, because the LRA ceases to express fully how to determine a priority between unregistered interests. It is also a topic of discussion within law because of principles that a proprietor of the land may be bound by an interest that isn't apparent on the register or bound to an individual who may not even hold the deeds seems rather contradicting to the agenda of electronic conveyancing. As an attempt to resolve this, it has been suggested that some overriding interests should be abolished, as it would be unreasonable or unrealistic to expect them to be registered. That thus draws this presentation to a close. I hope it has served useful, and thank you for watching.